Hello, hello, hello. This is Attorney Mike Revel coming to you from Chicago. As usual, I haven't left the country in, it's been a couple weeks at least. It's been a couple weeks, but I got some good stuff. This one is Alyssa's fault. I was looking for stuff and having a hard time, and Alyssa sent this to me, and it's absolutely fantastic. I also got a nice little clip from Hector Cam Clips and a few other odds and ends. But this business in DeSanto's room is fantastic. Let's do it, shall we?
Thank you.
Thank you.
Are you ready, Mr. Houck?
Yes, very well.
All right, let's go on the record in the matter of Nelson Houck, 24118.
Honor John P.
For the record, hear me?
Oh, I'm sorry. Nelson Houck.
Okay, thank you. And thank you for addressing it appropriately, at least from the shots up that we can see. Two things. One, your client is here for sentencing on his plea to an amended charge of disorderly conduct. I don't see Kevin Hamilton or Jeannie Tackett here. However,
okay, we got our man Goldpaw. He keeps his pants on for this hearing, which is nice. It takes a minute. Have some patience. Let it develop. He goes full Dr. Seuss and starts making up his own words. It's fantastic.
the court can still proceed in this manner.
That is correct, Your Honor.
And there's also the request, we'll just handle this on the record as well, regarding use of marijuana while on bond. And counsel, as to the sentencing.
As to sentencing, Your Honor, you indicated use of marijuana while on bond. I'm not aware of that.
Well, so Mr. Houck had submitted proof of a medical marijuana.
Oh, that's
card.
correct, Your Honor.
And he had one prior to the arraignment that expired, so then he renewed it during the arraignment or during bond phase. And so my thought was that we would chat about that today.
Oh, okay. I saw that in the, but I wasn't present originally. Fine, Your Honor. We've had an opportunity to review the pre-sentence report in this particular matter. Your Honor, this has been an ongoing matter. It's been a lengthy negotiations. This matter actually occurred back in September of 24. I reviewed the video of the arrest. I filed a request for the video of the incident, and we're informed that the actual video
The McDonald's meltdown, as it came to be known,
of his time at the McDonald's was never in existence. We discussed his involvement in this matter and the reasons why this occurred. As to the general background information, as you can see, Mr. Houck has not had an easy life. Some of it is of his own doing. Some of it is because of the early stages that he went through. Ended up with the being, excuse me, and I apologize, Your Honor. He's been diagnosed with behavioral problems, clinical depression. His parents never married, and he became a ward of the state at age 7.
acute victim syndrome. He is the product of our culture. He has absorbed every excuse in the book, and you're going to hear about it.
I'm sure the state did as best they could. However, as the court is well aware, that's not the best of all circumstances. He did complete high school. However, he did not graduate, and he received his GED. He also indicated that, and in here, that he has a paralegal certification.
So he didn't complete high school. He sat there, probably handcuffed to a chair, until he was too old to remain there, and then they kicked him out. And then later, probably after a conviction, because he had nothing else to do while incarcerated, he got a GED. I'm just going to fill in the unsaid here.
Trust me, my discussions with Mr. Houck, he's clearly learned a great deal during his paralegal training. He's indicated his health is decent. He's on parole.
He's learned so much that he is now starting his own language. I mean, he's an overachiever.
Has been for approximately 3 years. His parole officer is aware of all that is going on in his life. I did not speak with the parole officer, but I did carry on some other conversations with Mr. Houck regarding that. To be honest with you, Your Honor, and I know he wishes to make a statement, but as you can see from his statement, he was at McDonald's. He was there to pick up some food. That's why he was in the area. Things got out of hand. He felt that he was being mistreated. I guess one thing leads to another, and when you
know how things get out of hand at McDonald's? Like, you know, we've all been to McDonald's, right? You can't just get in and out of there and get some food and go about your day. You've got to have an incident. Clearly.
review the body cam, it's clear that when the officers arrive, he is attempting to tell them what really happened in there, asking, hey, I need my witnesses, and they're just saying, well, no, and they're just responding and making an arrest, whether, you know, rightfully or not, but he was, and you can see that what occurred and what triggered the incident in McDonald's, and I'm not saying he's not taking responsibility, but in his mind at that time, regarding whose fault it was or whose fault it wasn't, and as you can see from his statement, the long story short is I was in the wrong and split this. I think, Your Honor, that this all carried over. And so I know that the recommendation is for incarceration. He's had 3 children. He has a 4th on the way. I believe she's pregnant. I know she's pregnant, and she's due in about a month and a half. He is not employed at this point in time, though he is still going out and looking. And as, again, one of the things on his parole is, as he told me, for the 3.5 years, he hasn't violated, his probation officer has not found a reason to violate, which is good. And I'm not suggesting, in fact, he's told me that he does not believe that he'll be violated for parole on this one. However, Your Honor, I'm asking that the court place him on probation. He does have another matter that's in Lansing Circuit Court. His parole officer is also aware of that. And as he's indicated to me, that's set for hearing, and they're aware of this matter as well. He's on probation not probation, but on bond out there. He's on a tether out there, and he's been in full compliance out there. I don't believe that incarceration at this time would be the appropriate remedy. He is the sole child care support. He's trying to get SSD. That's under appeal. as he told me, what he's trying to do, Your Honor, is to, he also is attending mental health treatment, and he's trying to get better. He recognizes his past and recognizes that he cannot continue that way, and he's trying to move on. I don't believe that incarceration at this time would be beneficial to anyone.
Well, what would you suggest, counsel? Because the individual in this matter, well, first of all, the way that I would view the facts of this case is that Mr. Hauk was dissatisfied with the time it took for him to be served or to pick up a mobile order, whatever it may be. So he decided to then go behind the counter himself to get his food. Then proceeded, when an employee was attempting to prevent him from doing that, proceeded to assault that employee. Now, your client also, in addition to his lengthy criminal history going back to 2008, has a number of assaultive crimes. Currently on probation, on parole, and he's also out on bond on another matter prior to this matter.
That's in Lansing, yes. Yes, sir.
I understand that.
No, I'm just saying.
But for parole to not violate Mr. Hauk based upon this incident and this behavior, and for bond violation to not be occurring, I'm not sure if it's occurring actually, I don't know if that occurred, but also for parole violation to not occur on the Lansing matter, I think serious concerns for the safety of the public and individuals in general, given Mr. Hauk's tendencies for violent behavior. This was over a mobile order for food that Mr. Hauk was tasked by his boss to go pick up. This matter was scheduled for jury trial, and quite frankly, the prosecutor at that time thought that it was in the best interest of justice to offer this matter.
It does indeed get worse, and we're about ready to go sideways very soon.
Or this plea in this matter. And quite frankly, I don't see how I have a choice other than jail for Mr. Hauk. Because the purpose of probation is to afford somebody an opportunity to learn from their behavior, fashion conditions to help them modify their behavior. I have zero rehabilitative conditions that I could offer to Mr. Hauk. Zero. I have zero confidence that any of the conditions that I would typically put forward for somebody in a matter like this, that any of those conditions would be rehabilitative.
Well,
At all. Mr. Hauk, I am flabbergasted that you thought that it was your right to go back behind a counter of a place of business that you are not employed. And then when somebody attempts to stop you, you assault them.
Ma'am, can I speak? Are you asking me as far as opening the floor for me to speak?
Sure.
Okay, well, ma'am, I think you're misinformed on the incident that happened there. And that is why, if the video would have came out, it would have showed the true actions of what happened there, ma'am. And I don't know where you're getting the information of. I was upset about how long it took or anything like that. Ma'am, that is not accurate information at all. There is a police call. There was video evidence. You would have heard all these things if I'd have went to trial, ma'am. But the video was somehow lost, but 14 seconds of another video to show two heads bobbing in was found, which is mind-blowing to me. And I'm flabbergasted that justice isn't thinking, where is the evidence? Why was not evidence preserved at the time of a crime that you said you seen me commit from a video image? So why was it not preserved? That is the flabbergasted part to me, ma'am, that you are condemning me in your head already off of facts that are not true. There's no base, there's like no factual basis for what you're saying, besides word of mouth. And anyone can write down their version of the story. We, like, ma'am, and I know, ma'am, there's 3 versions of every story, but one version doesn't lie, and that's video evidence, right? And
I think what he's trying to say with the Fabergasted is this.
I think this is a fallacy of misbalance of justice.
And somehow somebody scrubbed the video evidence because they didn't want the truth to come out, ma'am. So,
Sir, pause just a moment. I don't know if anybody scrubbed any evidence or
the video evidence was never produced, ma'am.
Sir, if you'd like to make a statement that the video evidence isn't available or whatnot, you don't know what happened with the video evidence. I don't know what happened with the video evidence. I don't even get the ability to see the video evidence unless it's submitted pursuant to the rules of evidence. And since there is a plea in this matter, that never was
I would
an
love
issue.
to go to trial.
Excuse me. As far as when some of it's in your own statement, sir, regarding you were ignored for around 5 minutes. So that was in your own written statement.
Ma'am,
So
in my written statement, I confirmed that I stood in line waiting. I stopped a different worker, not even the worker I got into an altercation with, ma'am. I stopped a totally different worker and asked him a simple question of, hey, when does these numbers and I didn't say it with aggression. I didn't say it with irritation. I said, hey, can you please tell me when do these numbers transfer over to these numbers so I can get my order and go? I said, I already paid for the food. It's already done. And before he could even answer, the person who I got into the incident with came rushing over, intervened, what's going on here, with an attitude. I didn't get an attitude back. I just explained the same thing to him, man. I showed him the picture I had. I showed him the screenshot I had that confirmed the order was already paid for, confirmed everything was done. I didn't even need to even come talk to nobody for real, man. All I had to do was be handed it back and go, right? So I didn't go in here looking for an incident, ma'am. I did not. This is not like a...
Sir, I didn't say you went in there looking. Sir, I didn't say you went in there looking for an incident.
No, but you said I'm in there violent prone, ma'am. You're trying to paint a picture in your words. You're trying to paint a picture of this big violent person. Ma'am, do you know how long it's been since I've been accused of a violent crime besides this one? It's been years. I have been working on... Yes, I've had a violent past. Yes, I've had a history. Ma'am, I was taken from by the state at the age of 7. I was raised in placement homes and lockup facilities. I was never given a chance at true life. I was given the chance at being a caged animal. So then when you ask me, am I prone to violence? Yes, sometimes I do have what I'm diagnosed with, explosive behavior, ma'am. And that's only when pushed. All my violent record I have is assault and batteries. All those are from being locked up facilities, fights in a lockup facility. None of those are from street altercations, being in the real world altercations, ma'am. So I am not violent prone like you think I am. I was in a cage situation with other violent people and situations became violent. I learned not to allow myself to be a punching bag to other people. Yes, and because I did more damage, I got charged, ma'am. I can't help that.
Sir, your matter out of Utah in 2018.
Yeah, 2018. How long ago was that, ma'am? How long ago was that? 18. This is 20. We're going on 26 now, ma'am. That's
Sir,
years.
Sir,
That's years.
At the time of this incident, that had been 6 years. So
Right, 6 years since I had a violent outburst.
Excuse me. That was aggravated assault resulting in serious bodily injury. Was that, were you in custody during that offense?
Was I in custody during that offense?
Yes.
Ma'am, even on that case, there was never no evidence presented.
Oh, so you weren't. You're stone cold busted. And she called you out and she has the information. Now shut your hole.
I played out because I was in prison for 3.5 years fighting the case already. So it just made more sense to go home, right? Take the deal that was offered to me and go home. And that was one of the cases on the deal. Ma'am, I didn't get caught on this crime at the scene. I got caught on, they reported this crime 2 months after this alleged crime happened. Ma'am, you're speaking on something you do not have the facts to, ma'am. You do not have the facts to these things. So you're still you're trying to justify in your head why you want to give me incarceration, which is not in the interest of justice to incarcerate me, because there are mitigating factors to this case that you are not even taking into consideration, ma'am. You're not. All you have said since you said something to me is about, oh, he's a menace to society. Ma'am, I did not go, this was not random. I was a working father at work who was denied his food because the color of my skin, and it was noted in the phone call that he made to dispatch. If you'd have heard that phone call when he said it's a black and he threatened my life, come quick. And I never once in fact threatened this man's life. In fact, ma'am, I asked him multiple times to take his hands off me before I even touched him, ma'am. Before I touched him, I asked him multiple times to take his hands off me. I informed him he was committing assault by putting his hands on me. Unwanted touching of any person is assault. Assault does not have the right to put his hands on me, no matter what you say.
Mr. Hawk.
In fairness, he's a bit of an expert on assault because he's committed a lot of them.
Yes, ma'am.
You entered a plea.
Are you justifying that he has the right to put his hands on me, ma'am?
Sir.
He has that right? Can you clarify this for me?
I mean, he still has it wrong. What he described as what's called battery, but that's okay.
Have it on record, please.
Listen, that matter is not before the court for this court to make a determination.
What you're damning me off of.
Excuse me.
Ma'am, I'm sorry. Give me the time you're going to give me, ma'am, but I cannot sit here and let you lie on me and condemn me in your head as like this violent individual, and I'm not, ma'am. I'm not. I'm trying to
Lean on me.
and you're not even giving me the opportunity to
Stop interrupting this court. Stop interrupting this court right now. Stop interrupting the court. This court has the information that it was provided after an interview was conducted between one of the probation officers and Mr. Howe. This court also has the criminal history of Mr. Howe and the statements of Mr. Howe, as well as the copies of the police report and statements of individuals at that time. Since there was not a trial in this matter, this court doesn't have the any additional evidence that may or may not have been introduced at trial, such as any body cam, any videos that may or may not exist or whatnot. And so this court is basing its ruling and its order for sentence on what it's previously stated on the record. Specifically, the information this court has as far as what occurred in this matter, again, based upon the reports and reviewing the statements of both Mr. Houck and the victim in this matter, and I think there was an additional individual that was named as a victim, but then indicated it was because they were trying to separate the individuals. This court's not making a determination as to who put their hands on who first. This court hasn't heard any testimony regarding that. All this court is doing is going based on the plea that was put on the record and the facts that this court has before it. Therefore, the court is going to, as I've stated before, the court does not find that there's reasonable grounds to depart on MCL 769.5. The court does not find that probation will be beneficial to Mr. Houck. The court also is taking into account that Mr. Houck is currently on parole for a matter, as well as currently out on bond in another matter out of the Lansing Circuit Court, Ingham County Circuit Court. And therefore, the court does not find that there would be any suitable rehabilitative condition for Mr. Houck to participate in probation on. Therefore, this court's going to order $45 days jail, credit for 1 day.
Ma'am, can I ask something real quick, please? as far as the credit timing goes?
You had 1 day credit, sir, for the day you were incarcerated and bond was posted.
Yes, ma'am. Can I just ask you something? If not, it's okay. I keep my mouth shut if not, ma'am.
What's your question regarding your credit for time served, sir?
I also did 14 days in jail on this incident too, but that was through my PO.
That was for what?
That was through my PO. I went and turned myself in after this incident and did 14 days also through my
You say
PO.
PO.
Your parole officer?
Yes, sir. Yes, ma'am.
Okay, so that's on that matter. So there's not, I'm not affording any credit for time served
Oh, sucks for you. That was a parole violation. No credit. Next.
on this matter.
All right. It was due to this matter. That's why I was wondering.
I understand that, but that was
I was not-
MDOC, that was as a parole violation, so the court's not.
So that was a parole violation then?
Yeah, I did get violated for this incident and the other incident. I've done 14 days on both of the incidents I caught. In 3 years, I've only gotten in trouble twice, which is an outstanding job for most people on parole.
Okay.
I wasn't
So,
aware
all
of that, sir.
right, that's, okay.
Well stated, Mr. Low Expectations.
The court's going to do the 1 day credit for time served, and the court's also going to order restitution if requested. As of this point, it does not seem to have been requested, but there may be a request, I'm not
And then if
sure.
he has a right to, we can have a hearing on that.
Of course.
No, I understand.
All right, as relates to your date to report, sir, the court will give you until Friday to report. So you need to email into Ms. Shine so she can give you the information regarding that report date and how to report and where to
I
report.
wanted this is Ms. Short.
I mean, Ms. Shine, did I say short?
No, you did say Shine, but I believe this is Ms. Shaw.
Oh, Michelle, okay, either one in your probation. And then also as it relates to your medical marijuana card, you have something in here from a cannabis doctor. It appears, but not
Oh, he might end up in the honor dorm. I think that's what he's trying to say.
from a treating physician. And then the question I had was because it says that you didn't have any, you were not under a doctor's care, you're not taking any medication at this time. Given that this court's not placing you on probation, the court doesn't find a need to continue to address that issue.
Thank you, Your Honor.
Is that it?
Just make sure you email to Ms. Shaw.
Okay.
Good
So
luck.
I'm done now, though?
Fine?
Yes, you're all set.
Okay. What time on Friday? Because my fiance doesn't get off work till like 6 on Friday.
Okay, well, that's fine, I'm having you email Ms. Shine, email her by 12:45, and she'll communicate all that with you, okay, sir?
Okay. And then, so I'm done, right? I'm judgment and passed down, right?
That's
Yes,
correct.
and if you want to appeal it, you certainly have a right to appeal it.
Well, at this point, I'd just like to say that your fucking court is a joke. A joke, and you are carrying your fucking self.
Sir, you are on
It's
the
not in
record,
court, so.
and this is a court of law, and that's not acceptable.
Okay, Rita. Stephen Proudly here.
And we end with a bang. It was fantastic. It was fantastic. It took a minute to get going, but it was well worth it. Thank you, Alyssa. Now we got some knucklehead pulling one of the oldest gags in the book. It's kind of fun.
For the record, in the matter of the city of Lansing versus Stephen Proudly, this is 250-292-5911. Mr. Proudly, this is a show cause. That's for a text messaging. You owe $210. No, yeah, so $210 is what's due. Looks like there might have been some partial payments made.
Yeah, they refused my payment.
They refused your payment?
Yeah, because I was paying in pennies. That's why I'm here. They refused my payment.
Doesn't really matter, but
This is a waste of time.
Floyd?
No,
The old pain and pennies gambit. It's kind of fun. You know, it's weird. They used to accept it though. Here's the thing where I think he's actually got a bit of an argument. I mean, he's a jagoff. I don't care. But theoretically, this is legal tender. And the very definition of legal tenders is that if you offer it in compensation and someone refuses it, you don't owe it anymore. That's it. That's it. That apparently is not how the world works. I don't know. I don't really care. But he can't articulate that clearly. She just runs him over. It's fun.
disability, more income.
No income, you're not
Low
employed?
income,
Low income?
yeah,
Okay, you're not employed?
no,
Okay, how do you, what income are you receiving?
social security disability.
It looks like I see you were trying to make payments with the $5 payment, you say you were paying in pennies?
Yep.
It does say that, defendant paid with gold pennies. Defendant instructed to write name on each roll per court policy. Was that the issue?
Well, they said they can't pay more than $5, 50 cents a penny. I said, yeah, that's U.S. government money.
You said they can't do what?
They can't take more than 50 cents a penny at a time. And they even have a sign out there. And I don't care what that sign says, it's money. You have to accept it.
We take 50 cents and pennies. That's it. Up to 50 cents.
Thank you.
You're welcome.
You can't take it to get it converted?
Well, I went to the bank and flip to get penny. I was paying my bill. You guys refused
You
it.
say you went to the bank to get pennies?
Yep.
What do you mean? How did you get pennies from the bank?
I went there and requested 5,000 pennies.
Why?
Paying my ticket.
Why didn't you get $5 in bills?
I'm paying my ticket in U.S. current money.
Oh, okay. Well, we have a policy, which she just, don't talk over me. Don't talk over me. We have a policy here at the court that we cannot take more than 50 cents in pennies. If you're going to go all the way to the bank to request money, then you can follow the court policy. So you're not going to create our policy for us. Do you understand that?
Is that a federal law to refuse money?
Is it a federal law? This is a state court.
Or state court,
Okay.
whatever.
No. We have a policy on how we receive currency. You're going to follow the policy or a benchmark's going to issue.
I'm paying dimes then.
There's a policy on how much.
Why don't you tell the judge that it's the creation of currency, and that's specifically a federal issue, and they preempt the field, and that they don't have discretion to not take the currency of the nation that they're part of. Okay, whatever. I don't care.
Dimes as well. We can give you a copy of that paper.
Oh, I seen it.
Okay. So if we play a game, we play a game. Sitting in court, all the policy in jail. Do you understand that? And you don't want to sit in jail for text messaging.
Okay.
Yes.
Long as I pay 5,000 coins, 2,000 coins.
Policy. Give a copy of that, whatever it is. I don't care. Just follow the policy.
And it doesn't have.
If you followed the rule in the first place, you wouldn't be here.
I'm trying to
Be
pay
a
my
rule,
ticket.
be a rule follower. That's all you got to do. Follow the rules. Don't break the law. Then you won't be in here paying on a texting while driving ticket.
And I'm still on my phone.
When are you making your next payment?
When I can,
What day is that?
when I get money,
I don't know when that is. I'm asking you a question. You're going to answer me, or we're going to move in a different direction.
probably next week sometime.
Defendant will pay in 7 days. $5, you're saying, is your payment?
Yep, and coins.
I don't care how you pay it, dollars or coins. Just follow the policy. So we state here, you're gonna pay $5 within 7 days according to the policy,
Thank you. You sure did.
and $5 every 14 days, because I'm not gonna be collecting on this until my retirement.
You guys are taking 2.5 years to pay it
That's
off.
within every 14 days, or I'm issuing a bench warrant.
Yeah, see, there's the problem when you want to play jag-off games with the judge, because they have more ways to pull your chain than you have to pull theirs. But you do it your way, brother.
You're all set.
Do I get any paperwork?
You do not.
You'll get nothing and like it.
That's right.
Evelyn? Or Evelyn?
You're gonna get out there first.
Coming up to this process.
Nothing really happens here, but this guy's such a vibe. I had to do it. It's short.
And you're gonna head on back to your cell for now.
All right, the decent exposure scores of 12. What does the state feels appropriate?
Your Honor, the state's requesting bail in the amount of $5,000. Mr. Bobos has a misdemeanor conviction from July 14th of this year for draw a deadly weapon in a threatening manner. He has a 180-day suspended sentence in that case. He has a gross misdemeanor arrest back in May for destruction of property. Looks like we no issued that for additional documentation regarding damages. A misdemeanor conviction for possession of drug paraphernalia. Looks like that was an incline and he failed to appear for his review hearing in that case. 2024, he's got several arrests for failure to appear. It looks like he's got a possession of drug paraphernalia conviction. And then he's got additional misdemeanor arrests and convictions between, looks like date from 1998. So lots of criminal history. So the state's requesting $5,000 bail due to his risk of continued criminal conduct and failure to appear.
Honestly, I think she should just use my clip every time.
Behavior in this case is disgusting.
Spence?
Your Honor, I see that the request for a public defender was denied. Would you like to appoint us at this point in time?
Well, I'll ask Mr. Bobos if he wants to apply for the public defender. You want to? All right, raise your right hand. Do you solemnly swear or affirm under penalty of perjury the evidence and testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yeah.
All right. What's your income?
I'm filled with confidence. I don't know about the rest of you. Yeah.
I think I'll.
All right, I'll appoint the public defender. What's the defense's position on bail?
Your Honor, as you heard, Mr. Bobos does not have any sort of financial means to make any sort of bail. He currently is homeless and doesn't have employment, but he's okay to do any sort of drug and alcohol testing that you require. We're hoping that you look at the fact that he's not able to make any cash bail and consider release on his own recognizance with those conditions that'll keep
If you got drugs that you seized and you just want to get rid of, he'll take care of them for you.
the community safe of drug and alcohol testing. That would be our request, Your Honor.
All right. To show by clear and convincing evidence that bail is necessary to ensure the safety of the community, the appearance of the defendant will be set at $10,000. The bail laws make all court appearances. August 15th at 9 a.m. is the defendant's next court date. We'll see you back then, sir. Evelyn?
Okay.
And then Went?
Well, then, can you state your name, please?
Here's another one where nothing happens. She's just a vibe. It's very short, but I was fabergasted. that grandma has such serious charges. I really was.
Your address is on Yodel Circle?
Yes, sir.
Okay, do you have an email address?
All small letters.
So,
Yes, sir.
all right, do you have a phone number, please? Okay, the state is alleging three charges against you. The first one is dangerous drug possession. The second is drug paraphernalia possession. And the third is misconduct involving weapons during a drug offense. All of those are felony allegations. You have the right to remain silent, right to counsel, and right to trial. I've scheduled you for a preliminary hearing on the 22nd of August at 4:00 p.m. You'll get a copy of this so you don't have to try to remember the information. The preliminary hearing is to determine if there's probable cause to charge you with those felonies. If probable cause is found, your case will bind over to the Gila County Superior Court. If there's not probable cause, the felony charges could dismiss. Your release conditions are the following. Obey all orders of the court. Do not commit any crimes. Notify the court immediately if your address changes. Do not leave the state of Arizona without permission of the court. Do not possess or consume any alcohol or drugs without a valid prescription. And not to possess any firearms. Since these are felony allegations, if you're convicted, you could become a prohibited possessor. I'm placing a $5,000 bond hold on you regarding those charges, so you'll remain in custody unless you post bond. Being that you're remaining in custody, you have the right to a court-appointed attorney if you cannot afford to hire one. I'll send you a financial questionnaire to fill out. If you're interested in having a court-appointed attorney, you can complete that. Being that you're held in custody on the felonies, the prosecutor has 48 hours from the date and time of this hearing to file a formal complaint against you. If they fail to file that complaint within 48 hours of today's date, then you'll be released on your own recognizance. Then the prosecutor has up to 7 years from the date of your arrest to file the charges. Do you have any questions on that?
No, sir.
All right, that'll be all then. Good. Could you state your name, please?
Anthony Lee Crawford.
Lee is your middle name?
Yeah.
All right, sir. Do you have a physical residence?
No, due to the disability tax, you don't. Computer and under license society.
Okay, so you don't have a residence?
No, I don't like going with, no.
Okay. Do you have an email address?
Yeah, it's my wallet.
Okay.
I have it at this time.
Okay. How about a phone number?
No.
Okay, well, we'll just hold off. I don't want to go with the possibility. We'll just wait till you get ability to report it to us. The state's alleging 2 charges against you. One of them is disorderly conduct. That's a misdemeanor violation. The second charge is aggravated assault to law enforcement officer. That is a felony charge. On both of those charges, you have the right to remain silent, right to counsel, and right to trial. On the misdemeanor, I've scheduled you for an arraignment on the 20th of August at 1:15 p.m. On the felony, that's scheduled for the 22nd at 4:00 p.m., and that's for a preliminary hearing. I'll explain to you the process for the arraignment first, which is dealing with the misdemeanor. That's where you'll need to be prepared to plead either guilty, not guilty, or no contest to disorderly conduct. Depending on how you plead will be what happens next with the court proceeding. All of those options, plus the penalty range, will be explained to you at that hearing. Your release conditions on that and the felony are obey all orders of the court. Do not commit any crimes. Notify the court immediately of any address change. Do not leave the state of Arizona without permission of the court. Do not contact the alleged victim in any manner. And then do not go near the location of the alleged offense. Regarding the felony, that aggravated assault charge, the preliminary hearing is to determine if there's probable cause to charge you with that felony, not convict you, only to charge you. If probable cause is found, your case will bind over to the Gila County Superior Court. They'll take disposition on the case. Your release conditions on that are the same release conditions on the prior, but also not to possess any firearms, because that's a felony allegation. If you're convicted, you could become a prohibited possessor. Also, do not contact the alleged victim unless it's for lawful law enforcement purposes only. On each of those charges, there's a $500 bond I'm placing, and then on the misdemeanor disorderly conduct, so a total of $1,000 to bond out. Otherwise, we'll see you on the next court date. Do you have any questions, sir?
Yeah, I'd like to talk to you FBI. 35 years of things have been difficult in my life, and I refuse to leave jail, and I don't want to leave jail. I want to be able to stay here until the FBI can determine everything that's gone wrong in my life, and and kind of on my mistakes and also other people's intentions, or if they can determine whether I should be found guilty of all the charges or just some of them. And the charge that I am found guilty on, I'd rather go to prison. Society is getting me in trouble and bullying my PTSD outside to push me into trouble, to be very negative, and then telling me that I can't get negative. I read something outside, so I want to be released from jail. I want to stay with the FBI visits me in this jail, please. Can I have a request?
Yeah, we're holding you in custody on those small bonds that I placed, so you're getting what you're asking for. The other thing is, if you want to call the FBI, just let the detention staff know that you'd like to make a phone call, and at their convenience, they'll give you the phone and you can make the calls to the FBI how you see fit.
I have a number on my wallet. Is that okay with that? It's all work. Yeah, it's all good. Thank you, Ron, and God bless you, sir.
Thank you. Have a good day.
Yes, sir. Thank you.
You bet. We'll get it sent over shortly. I got to do the 3 in Globe, then.
Well, that was a wild one. I've never quite seen that before. He rolled into it's society's fault. Look, who can't relate to the notion of who can't relate to the notion of yeah, you know, I try, but you know, everyone's just so freaking annoying. Like you can't act on that, but as a human, who can't relate to it? But he had a really odd approach, which is, this is both society's fault and some of it's my fault. I do bad stuff too. Everyone's at fault. Society, me, everybody involved. Everybody's at fault. So why don't you just keep me in jail? Which oddly is probably good for him. He's got a bail, so he's getting credit. He's probably going to be convicted of some stuff. You might as well just serve it right now. Although I don't know if he even wants to get out. It's a weird situation. Yeah, I guess that covers it right there. There you go. Fun stuff. There you go. There's the meltdown at McDonald's. And the other stuff I had sitting around. Thank you all for coming out. I appreciate it. I will see you all soon.